Go.
Um, Good day, attorney and our classmates. I and my group mates, Michael Anthony Bravo and Kristelle Claire Prado, are here to discuss the case of Municipality of Nueva Era, Ilocos Norte, represented by its municipal mayor, Caroline Arcedon Garbida, the petitioner, versus the Municipality of Marcos, Ilocos Norte, represented by its municipal mayor, Salvador Pilos, and the Honorable Court of Appeals, the respondent. GR number 169435, February 27, 2008. Um, we are hope that you will able to learn through our presentation. The primary issue in this case is whether or not the eastern boundary of Marcos extends over and cover the portions of the Nueva Era.
Hello everyone. Now for the facts and timeline of the case. First, let us discuss the geography of Ilocos Norte because not everyone might be familiar with it. So as you can see here in this map, the Nueva Era is on the southern part by the border of Ilocos Norte and Mountain Province and also Abra. And then Marcos is in the inner part of Ilocos Norte. So as you can see, it's not by the border of Ilocos Norte itself. Okay, next. So for the timeline, first in 1916, Nueva Era was created, and then afterwards in 1963, the Municipality of Marcos was created through the RA 3753. Now, in this specific statute, in Section 1 of RA 3753, it states that the barrios of Kapariaan, Biding, Escoda, Culao, Alabaan, Ragas, and Agunit in the municipality of Dingras, province of Ilocos, are hereby separated from the said municipality and constituted into a new and separate municipality to be known as the Municipality of Marcos. Let us remember that section because we will refer to it more often in this case. Now, in 1963, Marcos claimed that part of Nueva Era is supposed to be under their jurisdiction because of because in RA 3753 it stated that their boundary on the east by Ilocos Norte Mountain Province boundary. So Marcos Municipality asserted that they have claim over Santo Niño and the northern part of Nueva Era. Now, why the northern part of Nueva Era? Because according to the section 7C of the Local Government Code of 1991, section 7C rather, of municipalities should be contiguous. So if Marcos has claim over Santo Niño or the middle part of Nueva Era, so as you've seen earlier, yung map ng Nueva Era is pahaba, right? So kapag nakuha ng Marcos yung nasa middle part, mahahati yung Nueva Era and then yung northern part ma-isolate siya from the main portion of Nueva Era. So because of that, Marcos also claimed that the northern part of Nueva Era should be under their jurisdiction. Now, because of that, Marcos filed its claim before the Sangguniang Panlalawigan of Ilocos Norte. Next. So the SP ruled in favor of Nueva Era by the doctrine of expressio unius es exclusio alterius. This will be the overarching principle in this case. It will be referred to by RTC and SC also. Because SP explained that RA 3753 expressly stated that the barangays from municipality of Dingras. So the legislative intent of RA 3753 is to create a municipality from the existing barrios from municipality of Dingras. So since um since they explicitly said and listed all of the barrios which are supposed to be included, um they could not assert that they could claim further areas beyond those listed. Now, the RTC in 2001 affirmed the decision of the Sangguniang Panlalawigan by the also because of the principle of expressio unius es exclusio alterius. Oh, and also in the ruling of SP, the SP sided with the Nueva Era because the part of Santo Niño and the northern part of the Nueva Era is a part of an ancestral land which is to be protected. So they cannot just split those areas so they could conserve it more easily. Now for the RTC, going back, the RTC affirmed the decision of SP. The RTC cited the congressional records of RA 3753's deliberation, specifically in its explanatory note. It was stated that this bill seeks to create the province of Ilocos Norte, a new municipality to be known as the Municipality of Marcos, to be comprised of the present barrios. So the barrios that I've mentioned earlier, Kapariaan, Biding, Escoda, Culiao, Alabaan, Ragas, and Aguni. So they listed specifically all those barrios. Now, all in the municipality of Dingras, explicitly mentioning Dingras. So beyond Dingras, they could not claim any other jurisdiction. So as I've said here, since the law explicitly mentioned the municipality of Dingras as the mother municipality of those that will be included in Marcos Municipality, Marcos cannot add any area beyond the territorial jurisdiction of Dingras. Next.
For the ruling of the Supreme Court, um, the Supreme Court held that no part of Nueva Era's territory was taken for the creation of Marcos under RA number 3753, since only the barrios of Dingras are named in Section 1 RA 3753, which are the barrios of Kaparian, Biding, Escoda, Culao, Alabaan, Ragas, and Agunit. So therefore, the territory of Nueva Era is excluded. So under the maxim of expressio unius es exclusio alterius, the mention of one thing implies the exclusion of another thing not mentioned. If a statute enumerates the things upon which it is operate, everything else must necessarily and by implications be excluded from its operation and effects. These rules are as a guide to probable legislative intent is based upon the rules of logic and natural working of the human mind. Had the legislature intended other barangays from Nueva Era to become part of Marcos, it could have easily done so by clear and concise language, where the terms are expressly limited to certain matters. It may not be it may not by interpretation or construction be extended to other matter. The rule proceeded from the premise that the legislature would not have made specified enumerations in a statute had the intention been not to restrict its meaning and confine its terms to the express mention. Moreover, since the barangay of Nueva Era were not mentioned in the enumeration of barangays out of which the territory of Marcos shall be set, their omission must be held to have been done intentionally. This conclusion finds support in the rule of casus omissus pro omisso habendus est, which states that the person, object, or thing omitted from the enumeration must be held to have been omitted intentionally. In regard to the contention of Marcos in the paragraph 2 of the said act, which specifically stated the bounded on the east by the Ilocos Norte, Mount Province boundary. The court um, said that it cannot be accepted the contention of Marcos because only Dingras is specifically named by laws as sources territory of Marcos. Hence, the said description of the boundaries of Marcos is descriptive only of the listed barangays of Dingras as a compact and contiguous territory. Considering that the description of the eastern boundary of Marcos under the said Republic Act is ambiguous, the same must be interpreted in light of the legislative intent. The law must be given a reasonable interpretation to preclude absurdity in its application. We thus uphold the legislative intent to create Marcos out of the territory of Dingras only. The Supreme Court also ruled in this case that at the time of the creation of Marcos, approval in a plebiscite of the creation of the local government unit is not required. So therefore, um, the Supreme Court held that the Marcos cannot claim a portion of Nueva Era territory pursuant to its creation by virtue of RA 3753.
Hello, good morning, classmates. Tenets and principles in the statutory construction. Uh, Next slide. Uh, First, we will be talking about the legal maxim first, and then we'll be talking about how it is applied from the case. The first legal maxim is expressio unius est exclusio alterius, which is express mention and implied exclusion, which is anything that is not included in the enumeration is excluded therefrom, and a meaning that does not appear nor is intended or reflected in the very language of the statute cannot be placed therein. This was the main legal maxim that was used in the case, given that on March 29, 2000, the Sangguniang Panlalawigan of Ilocos Norte ruled in favor of Nueva Era, which they reasoned out that with the application of the rule expressio unius est exclusio alterius, no part of Nueva Era was included by Republic Act number 3753 in creating the municipality of Marcos. Under this legal maxim, the mention of one thing implies the exclusion of another thing not mentioned. If a statute enumerates the things upon which it is to operate, everything else must necessarily and by implication be excluded from its operation and effect. This rule, as a guide to probable legislative intent, is based upon the rules of logic and natural workings of the human mind. Expressio unius est exclusio alterius is applied, which in RA number 3753, the provinces and the parts in the said case was indicated, and uh, there were no other provinces indicated in the said case. Uh, this means that the expressio unius est exclusio alterius is applied. The next legal maxim we'll be talking about is the dura lex sed lex. Dura lex sed lex is a Latin term that means it is harsh, but it is the law. According to Scribd, this statement originated during the 11th century as principle of canon law or church law, which indicated that lex is opposed to jus, where lex is a law created by human, while jus is a natural law and cannot be modified by an act of legislature. On June 6, 2005, when CA Party reversed the RTC decision, which is wherefore we partially grant the petition treated as one for certiorari, the decisions of both the Sangguniang Panlalawigan and Regional Trial Court of Ilocos Norte are reversed and set aside, insofar as they made the eastern boundary of the municipality of Marcos coterminous with the eastern boundary of Dingras town, and another is rendered extending the said boundary of Marcos to the boundary line between the province of Ilocos Norte and Kilingapayao. But the same decisions are affirmed. With respect to the denial of the claim of Marcos to the detached northern portion of Barangay Santo Niño, which should, as it is hereby ordered to, remedy the municipality of Nueva Era. No cost, so ordered. In this case, uh, in the said case, Duralex Sedlex has been applied as they have been following what the said case is all about, in which the Republic Acts made is already considered to stop short at the eastern boundary of Dingras as the eastern boundary also of Marcos and refusing to go further to the boundary line. This is just talking about on how the Republic Act number 3785 was being applied in the said legal maxim. Next slide. Lex prospice non respice. The law looks forward, not backward. It is the basic norm that provisions of the fundamental law should be given prospective application only, unless legislative intent for its retroactive application is so provided. In this legal maxim, the summary of this is when the province of Marcos was made without the amendments done on the later dates in which this legal maximum was applied. Nueva Era contends that the constitutional and statutory plebiscite requirement for the creation of a local government unit is applicable to this case. Due to the lack of the required plebiscite, because back then, when province of Marcos was created, there were no acts or any rules from the law that is requiring any plebiscite. In such, lex prospicit, non-respicit is applied. Next slide, please. Casu omissus pro omisso habendus est, which states that a person, object, or thing omitted from an enumeration must be held to have been omitted intentionally. No part of Nueva Era's territory was taken for the creation of Municipality of Marcos under Republic Act number 3753. This conclusion on the intention of the legislature is bolstered by the explanatory note of the bill, which paved the way for the creation of Marcos. Said explanatory note mentioned by the congressman only Dingras as the mother municipality of Marcos. Where there is ambiguity in a statute, as in this case, courts may resort to the explanatory note to clarify the ambiguity and ascertain the purpose and intent of the statute. Since the barangays of Nueva Era were not mentioned, such that Durlex Sedlex was also applied in the enumeration of the barangays, any other barangay that is not mentioned should be omitted or should not be included, depending on the act or Republic Act made. That's all of the legal maxims that is applied. Thank you.
All right, thank you po for listening to our presentation and discussion of the case. If you have any other questions, you may refer to the comment section and place your questions there. We'll try to answer it as soon as we could. Thank you very much and have a great day.